Hello and welcome to today's podcast entitled The City of San Bernardino Proposed Bankruptcy Plan, an Evident Chapter 9 Bankruptcy Truth. Not all claims are treated equal, but are pension claims more equal? I'm Mark Vacha and I'm a member of the Public and Project Finance Group here at Cozen O'Connor based in the Philadelphia office. I would like to begin the program with a few disclaimers. The podcast is for information only. It does not provide legal advice nor create a client-attorney relationship, and the information herein is subject to change without prior notice. The podcast is subject to copyright 2015 of Cozen O'Connor, all rights reserved, and the analysis, conclusion, and or views expressed herein do not necessarily represent the position of the law firm of Cozen O'Connor or any of its employees or the opinion of any current or former client of Cozen O'Connor. Listeners should not act or rely on information in the podcast without seeking specific legal advice from an attorney on matters which concern them. Thank you. And now let us turn our attention to our topic. This podcast has three main purposes. First is to briefly summarize and highlight some of the significant points of the City of San Bernardino's proposed plan for the adjustment of its debt, and I emphasize it was as proposed and filed on May 29, 2015 in bankruptcy court, and therefore is subject to further revision as the process moves along. And this is partly to provide as an example of some of the very basic aspects of a Chapter 9 adjustment plan for municipalities. Second is to relate the plan to the public finance concern of how different types of bondholders, creditors, and other stakeholders are treated. And third is to evaluate what takeaways, if any, can be gleaned from this case for general governmental credits. It should be emphasized that the plan is subject to the vote of holders of impaired claims and may be rejected and or revised as the bankruptcy process proceeds. Although Chapter 9 cases vary in important aspects in their origins, the San Bernardino case seems to fit a pattern that is not atypical in California and would not be surprising were it to be seen played out in the future in other parts of the United States far away from California. Certain key circumstances surrounding the city's fiscal challenges and bankruptcy and will influence the course of the implementation of its adjustment plan and its prospects for an ultimate recovery. Specifically, these factors, which are interrelated to a large extent, consist of loss of major employers, limited diversification of the economy, significant legacy costs such as pensions, other post-employment benefits, acute reaction to the real estate market collapse associated with the Great Recession, high levels of poverty and related stressors, example crime, on public and social service demand and the business environment, and constraints either due to law or historical management practices or administrative culture or political factors, in the ability of the city to raise revenues or quickly implement cost-saving and efficiency measures. And while the causes of San Bernardino's fiscal stress are largely beyond the scope of our podcast, I found it interesting that a couple of legal matters in particular have been cited as making it difficult for the city to react to its problems. One is the continuing effect of California's Proposition 13, which has constrained the ability to raise local tax revenues. Another is the very extensive city charter, which many in the city have considered to be cumbersome to work through, and which delays the speed at which the city government functions. Now, the city's plan of debt adjustment, as proposed and filed with the bankruptcy court as of May 29, 2015, set forth 15 classes of creditors. We will briefly discuss each class to hopefully give an appreciation for the complexity of a municipal bankruptcy case for a general purpose government. First, however, we will discuss in a basic way the significance of classes for purposes of a municipal bankruptcy case. There are at least two main respects in which classification of claims is important. First is to organize the way the claims are treated. Second is that the ability of a debt adjustment plan to be confirmed is intricately connected to the classification of claims. A bankruptcy court may confirm a Chapter 9 plan only if at least one class of claims that are impaired has voted to accept the plan. Acceptance is achieved where more than one-half in number and at least two-thirds in amount of allowed claims voting in a class vote in favor of confirmation of the plan. And holders of claims in unimpaired classes do not vote. So the plan must also satisfy certain requirements both with respect to non-consenting members within a consenting class and with respect to non-consenting classes. The plan can be crammed down on the non-consenting classes over their objections, provided that the bankruptcy court finds that the plan does not discriminate unfairly and is fair and equitable with respect to each rejecting class. And although beyond the scope of our podcast, as a general matter, the fair and equitable requirement is usually not an impediment to Chapter 9 debtors. Given the requirement for at least one class to vote to accept the plan, it is in the interest of the city, like any Chapter 9 debtor, to have at least one class of impaired creditors who would clearly view the plan as better for them than leaving everyone to fend for themselves, so to speak, outside of a structured bankruptcy. We'll now discuss the city's proposed plan's 15 classes of creditors. And please note the actual class numbers do not have any specific significance in and of themselves. Class 1 consisted of claims of holders of a 1996 refunding bond issue, which were secured claims previously funded by the city through making payments on a lease of City Hall. And these claims are proposed to be impaired, involving the release of a reserve fund for the bonds and its replacement with a surety. Class number 2 consisted of secured claims of holders of 1999 refunding certificates of participation, also being previously funded by the city, and a related authority, making payments on several leases which will also be impaired and involve the release of certain funds to the city. Classes 3, 4, and 5 are unimpaired secured claims held by the California Infrastructure and Economic Development Bank related to the loan of proceeds of the CIDB's bonds to the city. They related to a street extension project, a fire station project, and a pavement reconstruction and rehabilitation project. Classes 6 and 7 involve claims of Equipment Financing Corporation related to a fire alert system and police station air conditioning units which would be impaired. The Class 6 claims would involve a change in the time of repayment, and the Class 7 claims would involve the release of collateral to the financing company, leaving it with an unsecured general claim for the portion of its original claim not satisfied by the released collateral. So here we see two different ways in which, as a general matter, claims could be impaired. One has to do with a change in the time of repayment, and the other had to do with the releasing of a portion of collateral. Class 8 involves secured claims related to a balloon payment due in 2019 that would be impaired by being extended to 2022 and amortized over that 3-year period. Class 9 claims would be unimpaired. These involved restricted revenues for certain revenue bonds and notes. Class 10 claims would be unimpaired. These are claims of CalPERS, which is the California Public Employees Retirement System, that will be paid in accordance with an interim agreement between the city and CalPERS reached through a mediation process. And we will discuss CalPERS further later in this podcast. Class 11 involves claims of consenting unions that are impaired, and these are based upon an agreement reached with one union representing city employees. The city's disclosure statement for the bankruptcy plan of adjustment, as proposed, indicated that additional classes could be added to the extent multiple agreements are reached with more than one of the city's unions. And Class 12 consists of retiree health care benefit claims, which would be impaired, consistent with a retiree settlement agreement. Class 13, which is fairly dramatic, involved the impairment of an unsecured pension obligation bond claims where holders of $50 million of claims would receive $640,000 plus interest over time. Class number 14 is another unsecured class whose impairment is quite noticeable. Specifically, this class of general unsecured claims would receive a pro rata portion of a fixed amount of $500,000, which would be about 1% of their allowed claims. And Class 15 relates to convenience class claims, whereby the holder of the allowed claims can elect to receive the lesser of its claims, or $100, within 30 days of the effective date of the plan. So the city's plan fell very hard on general unsecured creditors, as is not atypical in Chapter 11 bankruptcies in the private and corporate context. And the disclosure statement acknowledged the stating, while the city is mindful of the importance of its general unsecured creditors, the fact is that the city lacks the revenues to provide a greater return to such creditors if it is to maintain an adequate level of municipal services and address deferred infrastructure maintenance costs, which have become a critical necessity for the city. The dynamics of this case, while complicated, are in large measure driven by the realities of the city's relationship and participation in the state's public employee retirement system, CalPERS. And the city's proposed disclosure statement discussed that in September 2013, after the city was determined to be eligible for Chapter 9, the bankruptcy court appointed a bankruptcy judge from Nevada to serve as case mediator among the city and various mediation parties, consisting prominently of CalPERS, as well as the city's secured and unsecured bondholders, 2 unions representing police and fire safety employees, and an official committee representing the interests of several thousand city retirees. The city was unable to make monthly contributions of its employer's share to CalPERS between the petition date for the bankruptcy and July 1, 2013, and the city consequently became liable for unpaid arrearage for the period between August 1, 2012 and June 30, 2013 in the amount of $13.52 million. Now, CalPERS could have asserted a contract termination claim, which would have been calculated so as to take account of certain future funding requirements, and that would have exceeded all other claims against the city combined. CalPERS also would have large claims for penalties associated with the arrearage. So the city indicated that given this and the city union and retirees' substantial stake in the resolution of the CalPERS claims, the mediation first focused on the city reaching a settlement with CalPERS. And pursuant to the interim agreement with CalPERS, the city will pay arrearage to CalPERS, pay certain additional administrative costs of CalPERS, and agree to a covenant not to impair CalPERS under the bankruptcy plan. And the city's disclosure statement indicated that notwithstanding anything in the bankruptcy plan to the contrary, nothing in the plan is intended to or does impair or interfere with the rights of the city and CalPERS under the CalPERS interim agreement. And the settlement with CalPERS is incorporated into the plan, and consequently, in addition to any relevant state law protections, would have protections afforded by the bankruptcy process and the confirmation of the plan. Now, although not expressly stated in the city's disclosure statement, there are significant barriers to exit from CalPERS, which has also demonstrated a willingness to staunchly defend its position in various California municipal bankruptcy or distress situations. And the bottom line seems to be that the city has agreed to continue making pension contributions to CalPERS for the city's 2 pension plans, notwithstanding the fact that CalPERS is not characterized as a secured creditor. Although the city agreed to continue making contributions to CalPERS, the city's retirees found themselves impacted with respect to their retiree health benefits. The city's disclosure statement in characterizing the plan noted that pursuant to a retiree settlement, subsidies from the city for retiree health care benefits will be substantially reduced. The city's disclosure statement indicated that the reduction of these subsidies and related savings is expected to save the city $40 to $50 million. Now let us consider some potential takeaways from the San Bernardino plan, assuming the final plan is ultimately substantially consistent with what has been proposed thus far. At this point, it seems that where Chapter 9 bankruptcy may be possible, investors may begin to, or increasingly, lean towards secured bonds, particularly special revenue-supported bonds for essential municipal utilities such as water and sewer. Moreover, over time, there may be a movement toward tax-supported bonds that are secured by a statutory lien of some nature. The San Bernardino plan suggests certain things from a union perspective for future collective bargaining agreements. Essentially, to the extent that other business realities would allow the following trade-off, unions negotiating with local governments where there is some threat of a future bankruptcy may have an incentive to trade off medical or other OPEB subsidies versus pension or other compensation that may survive a Chapter 9 plan of adjustment. This is a general comment and may depend on the level of protections afforded to pension and other post-employment benefits under applicable state law. And put in more general terms, municipal employees and future retirees may become more cognizant of what their expected total compensation may be in light of bankruptcy risk and may differentially discount the value of certain compensation, such as health care and other OPEB subsidies. Caveating that this is just one observation and opinion, I think the most significant takeaway from the San Bernardino bankruptcy situation is that unsecured bondholders should be expected to have much less leverage than an independent public pension system, where exiting the system has high costs, including the impact on the ability of a municipal government to retain or recruit current and future municipal employees. I think local governments will realize, particularly in states with strong multi-employer pension plans like California, that in Chapter 9, a local government may be able to effectively wipe out the position of unsecured bondholders because there's the prospect of regaining future market access through some form of secured bond structure, and the risks of that approach, while not insignificant, are perceived to be outweighed by the cost of battling a public employee pension system and the associated dislocation of municipal labor and the government's human resource needs for retaining and recruiting talented public servants. Finally, although not necessarily in a formal or strict sense, but rather in some practical way, bondholders may increasingly view pension obligations as a form of parity or potentially priority debt obligation, at least where Chapter 9 becomes a reality. However, pension funding obligations, for both good and bad, can change over time due to a variety of factors both within and beyond the control of the related government, and thus may become a challenging rival claim to size and assess. To some extent, pension funding obligations have characteristics of both fixed and contingent liabilities. I'm pleased that you joined our program. If you have any questions, please feel free to contact me at mvacha@cozen.com. That's mvacha@cozen.com. We hope that you will join us for future podcasts regarding developments in the municipal securities markets. Thank you and have a good day.